Good afternoon. This is Bob Rutledge. I am a homeowner here in the neighborhood of Pebble Creek Subdivision. And the good news is, for most of us anyway, I won the lawsuit, and the people with boats, RVs, and trailers are now going to be made to adhere to the covenants and restrictions, which we all willingly agreed to. They're going to be made to adhere to them now. I will read to you the court decree, and then at the end of that, I will also discuss with you an action that I think we as homeowners should take against the attorneys that the Perrymons hired, and then turned around once the Perrymons got on the board of directors, hired the same attorney out of 525 attorneys registered in this county, hired the same attorney for the board, and then paid them $2,300 plus probably more. So here we go. I'm going to minimize this. Don't need to look at me. This has unfortunately become too much about me, but it's really about the homeowners who chose Pebble Creek Subdivision because it had restrictive covenants. We could have moved anywhere. We chose the neighborhood with restrictive covenants. This was filed on 2 days ago. Today is the 20th, Friday the 20th. And the bottom line is, I am the plaintiff. Tommy Perryman and his wife are the defendants, and they lost the case in every way, shape, and form. The only thing we were even slightly not liking was we think they underpaid my lawyer. That's another issue. He's still got to pay. So now he's got to pay my lawyer and his, as I told you was going to happen. All right, Robert Rutledge, the plaintiff, that's me. Tommy and Angie Perryman, they are the defendants referred to herein. A trial on the merits was concluded December the 3rd, 2019. And after both parties had the opportunity to testify and present evidence in the court, finds as follows. The defendants purchased real property. The Perrymans purchased real property located at 1023 Destin Avenue, Foley, Alabama, 36535, Lot 61, Pebble Creek Subdivision. They purchased that lot by warranty deed and took title to that residence subject to restrictive covenants applicable to Pebble Creek Subdivision. Restrictive covenants applicable to the Pebble Creek Subdivision. It is uncontested that the defendants have a boat parked at their residence. In fact, they had an RV parked in their backyard as well. And I have photographic evidence of it and presented it to the court. But they did move that one. And that at least some of the boat has been seen by the public and or the plaintiff. That would be me. The defendants were alerted to this violation of the covenants and restrictions and have refused to relocate the boat. I could tell when I got this far, I'd already won the case. The judge could not have stated it any better than I could have, but it gets better. The question for the court is, how do sections 2.13 and 3.7 of the covenants and restrictions apply to the specific situation? Here's the definition that I believe the judge inserted the exact wording of what I had put into a letter to all of our neighbors. Restrictive covenants have, as they should, a significant and substantial impact on the use and value of property. Restrictions, of course, restrict the free use of one's land. These are voluntary contracts. The defendants sought out their residence in Pebble Creek Subdivision, and they took the property subject to the restrictions. The court must assume that the defendants, Tom and Angie Perryman, thought living in a covenant and restricted neighborhood subdivision was of great value to them, or they would have moved into a residence without such restrictions. Argument by the defendants were that the two sections cited above were ambiguous. How many times have we as homeowners been told that by our board members over the past decade? This is an aside here, folks. When I moved here, I must admit I didn't read them and commit them to memory, but I thought I had a pretty good understanding of them. Then when I filed this lawsuit, I read them again. Then when I prepared for what I thought was the first and second times that we were going to finally go to court, I read them again and again. And then going into the final court, I read them again. Every time I read them, I said, oh, these people have been lying to, these people meaning board members of the past. Not all the board members, but anybody that repeated this crap about it being ambiguous. Our HOA rules, covenants and restrictions are plain as day. There is nothing ambiguous about them, as you will find out from reading the rest of this. The judge felt exactly the same way I do. The judge felt exactly the same way most of you do. An ambiguity is doubtfulness or uncertainty of meaning or intention in a contractual term or statutory provision, in distinctness or signification, especially by the reason of doubtfulness of interpretation. And then it goes on, furthermore, ambiguity exists where the term is reasonably subject to more than one interpretation. And then it cites law book, case law. It is well settled that there is uncertainty and ambiguity in a contract. Again, this is a definition. He's not talking about this particular situation here. It is the duty of the court to construe the contract so as to express the intent of the parties. Fair enough. But here's where the judge could not have said this better. In a plain reading of the two sections, meaning anybody in the world that can reads this, they don't have to have a law degree, of the two sections does not cause the court to find any ambiguity, latent or otherwise. When looking at the two sections, the court asks itself if there are two sections, clearly sets forth the restrictions of having a boat on the subject property. And let me state here, folks, I know you think there's a loophole here. I know you think you can keep your RVs and trailers. I hope let me restate that. My lawyer hopes you think the same thing, but it doesn't, okay? If the answer in section 2.13, then if the answer is section 2.13, then the restriction is no, a boat or other vehicles shall be permitted to be parked anywhere in the subdivision, including but not limited to lots common, temporary, permanently, unless totally screened from public view. Totally screened from public view, folks, means your neighbor can see it and they want to complain. Now, they may not complain. They may be afraid to complain. That's another issue. But public view does not just mean from being down in the street. In this case, the defendant is clearly in violation of the covenants and restrictions. Each fact witness, as well as the pictures entered into evidence, show the boat is visible from public view. And this was the funny part about it. They're the ones that provided all the fact witnesses and all the public view pictures with very few exceptions. So they provided our defense. Anyway, if the answer is section 3.7, then the boat shall not be parked anywhere, temporary or permanently, or otherwise enclosed or camouflaged, so as not to be detrimental to the appearance of the property from any lot line. The defendant argued that a fence enclosing the boat, no matter how short, would exclude the boat from being in violation of the restriction. This argument fails. The true intent of the parties was to keep the boat from public view in the subdivision. So, You could have a boat and it'd be below the line, and you would be, in most cases, okay, below the line of the fence, of a 6-foot fence. I wouldn't mind going to 8-foot fences, but a 6-foot fence, okay? Because that's what the limit is right now. Just because I can't see it from the road, if your neighbor's lot stands above yours and he looks down into your backyard, they can see it. So keep that in mind. If they want to complain about it, the complaint should be heard by the HOA. And if it's not heard, the neighbor, like myself, can sue you to get it removed. Let's continue. As stated above, the court finds no ambiguity of the language in the competing sections. You know, since I've been here, that's all I've heard. It's too ambiguous. It's not clear enough. I look back after a few months of listening to that line, I finally figured out it was just a bold-faced lie. That anybody that passed along that lie was simply trying to gaslight people. Gaslighting means that when you read something, learn something for yourself, and you believe it in your heart that it's one way or the other, someone comes along and tries to misinform you and make you think that you're wrong about your thought processes. It's a form of psychological warfare, if you will. And that's what's happened to you in this neighborhood for 10 years. These people, and they know exactly who they are. I'll be glad to call any of them out. One in particular stood there and lied time and time again about this. And I'm going to call you out from now on. You know, I'm 64 years old, about to turn 65. I feel like I've gone through life without spreading too many lies. I think we're all liars when you get right down to it. But to spread this lie and this hoax this long without coming clean, there's no excuse in it. So I started calling this person a liar to their face. Hi, Mr. Liar. How you doing? I digress. Additionally, looking at the headings of the sections makes the decision of the court that much easier. Really, let's read this whole 2 parts right here. As stated above, the court finds no ambiguity of the language in the competing sections. Additionally, looking at the headings of the sections makes the decision of the court that much easier. Really, it should make your decision that much easier. Regarding section 2.13, it is under the heading of Article 2, General Land Usage, and the actual section heading is Vehicles. That causes the reader, here the court, or the landowner who took to look for general property usage restriction of vehicles, like or a boat, or an RV, or a large trailer that protrudes over the top of the fence. Under this section, regarding that 3.7 is under section, regarding 3.7 is under the section heading Article 3, Architectural Committee Review and Architectural Control. And the actual section headings is garages, okay? The reader, more importantly, the landowner, when looking for restrictions on a boat in the subdivision, would not go to this article or section for authority. This section would be for the construction, design, or use of a garage when looking for guidance on the permissibility of parking a boat at the residence of the homeowner, of the landowner, and would obviously refer to section 2.13. Any argument to the contrary is reasonable for a lawyer, an attorney at trial. Why? Because attorneys at trial can lie. We all know that. We see it done every day. But to argue that the landowner was confused, see how the guy holds attorneys in lower esteem, was confused and looked into section 3.7 for boat restrictions in the backyard is a stretch at best. Here's the money parts. Therefore, a permanent injunction is hereby granted against the Perrymons, the defendants, directing them to remove the offending boat and any other vehicle that is in 2.13, unless it is totally screened from public view. If the boat may be seen, however slight, from the roads of the subdivision, then it is not screened from public view and is therefore in violation of the covenants. Let me also state what is obvious: if your neighbor can see it, that's public view as well. Love your neighbor. Heard that's thrown out by these folks, yet they don't. If I did something like this to offend my neighbor, I would have put my boat up, even if they were the only one that ever complained about it. A lot of people won't complain. They just suck it up because we're old and don't want to fight anymore. So remove the boat because it is in violation of the covenants and that golden word, restrictions. You know what covenants means? It means we enter into an agreement together. We have an agreement that we're going to both abide by. And the covenants just happen to be restrictive. The plaintiff, that would be me, is awarded reasonable attorney fees, which I don't think is reasonable, but that's an argument for another day, of $7,500. In other words, the Perrymons have to pay my lawyer $7,500. They have to pay their own lawyer probably $15,000. My lawyer wanted $21,000, so he only got a third of what he wanted. But the Perrymons are not in the position to be negotiating with their lawyer. They'll be paying full price. Going to the next part of the argument here, I just want to make sure that part of our dues haven't gone toward paying the Perrymons' lawyer. I'll talk about that in a minute. Additionally, the judgment for the plaintiff, for me, as to both. So additionally, the judgment is for the plaintiff as to both counterclaims. So I win the counterclaims. All issues, counts, or complaints not addressed specifically are deemed denied. Judge Clark Stankowski. Okay? December 18th. This needs to be entered into the HOA meeting minutes at the next meeting so that 10 years from now, we're not still fighting this because there were liars when Adam and Eve were around. There are liars now, and there will most certainly be liars then that want to try and obfuscate and gaslight the true meaning of the black and white words that are in front of you now and the black and white words that are in front of you in the covenants and restrictions. And let me also state to you, there's an extension to those covenants and restrictions, and they're called the architectural rules. And some of you are in violation to the size of the shop buildings that you have on your lot, or you may have had too many buildings on your lot. Now that this is behind us, I'm ready to go for that one too. So get ready. This is going to be changed, and we're going to do this to enhance the reputation and the amount of money that these pieces of property are worth, because this is still the best neighborhood in Foley, Alabama. Now let's go to part two. Their lawyer was so the Perrymons, before they were ever on the board, hired a lawyer. I forget the guy's name, an individual lawyer, but he worked for a company called Stone Crosby. And then the Perrymons and 4 other people who had never been on the board before got on the board a year ago. Now they've all been reelected by acclamation, is my understanding. I have no problem with that. But they ran. Nobody held a gun to their head. But now they're going to have to answer to this because all 5 of them are implicit in picking this lawyer. They wound up hiring the same lawyer that Perryman hired. There are 525 lawyers registered in Baldwin County. They did not have, or nor should they have done, because of the look, how bad it looks, exactly the same lawyer, and turned around and paid him $2,300. So as a homeowner, whether I'd won this or lost this situation or not, I am now demanding to get that $2,300 back, and the Stone Crosby needs to be removed as the lawyer from the board. Perryman was his first. Perryman hired him first. There's a conflict of the appearance of a conflict of interest here. I will be filing a complaint against the ethics committee with the Alabama Bar Association. You are welcome to join me on this, but we all should demand. See, I know this wasn't even brought up at that meeting just a week ago. We all should demand that money back. That is 10 homeowners' dues for a year were pissed away to Perryman's lawyer. And if they wanted to hire a totally different lawyer for the board, that'd have been fine with me. But it's not fine with me when they hire the exact same one. And I think that most of you who are reasonable will see it that way. Now, moving forward, let's not drag this out any further and cost you any more money. If something has occurred once, it's far more likely to occur a second time, a third time, and a fourth time. If it had never occurred, then it's not so much likely to occur. This lawsuit happened. This lawsuit was egged on by the Perrymons' friends. In fact, they filled the courtroom that day. I wonder if any of these friends of the Perrymons now are going to step forward and split that $20,000 bill and pay it equally, since they egged the guy on. Okay? And now, if any of y'all are going to have to be persuaded to move your boat, your RVs, your large trailers that can be seen over the top of the fence, if you're going to have to be persuaded of that, I think it's very likely that it will happen, because it's happened once. And like I said, the 2 or 3 of you that have storage buildings that are excessive in their size according to the Architectural Rules Committee, understand that I don't give a happy rat's rear end about an individual had given you permission. That dog didn't hunt in this trial. It's not going to hunt in the next one either. If the building is bigger than what is specified by the Architectural Rules Committee, you're in violation of that too, because the architectural rules are written out, and there are copies of them floating around here, and they are, by definition, an extension of your covenants and restrictions. So let's all clean up our act. Let's make this neighborhood great again, or even greater than it already is. You know, a lot of you are to be commended, because when this first started, a lot of you got rid of your boats and RVs and trailers. But there's been a handful that have talked bad about me on Nextdoor, talked bad about me in public, and giving me the stink eye when they drive by the house. None of these things hurt me, folks. Again, let's not make this happen again, okay? The ball is in your court. Move your boat, RV, trailer, whatever, off of this property and get it done by the first of the year. Have a Merry Christmas and a Happy New Year, especially to the rest of you.